The objection is still pending.
Okay.
I'm getting information.
May 10th, 2022.
This is for C35 or for both of them? May 10th, 2022.
Was the first pregnancy meeting.
All right, so that would be C35. Um, 2022 at approximately what time was this meeting?
2 p.m.
And who was present?
Dan Lowndes, Elizabeth Peterson, Laura Weiner, zoo manager, Joanna Soto, zoo manager, myself, and Shannon Meyer, employee advocate.
All right, that went a little fast for me. After
Sorry
Elizabeth
about that.
Peterson, Julie Weiner? What was the name for
Laura.
Laura Weiner? And then go ahead.
Did you get Joanna Soto?
And then was there another?
Myself.
And you.
And then the employee advocate, Shannon Meyer.
And then what is this recording, an audio recording of the entire meeting as it occurred on May 10, 2022 at 2 p.m.?
Yes.
Has it been edited or doctored in any way?
No.
And what is the audio recording going to show?
It shows the discussion that I had with Dan Lowndes and the management team, where they said that I would they asked me to join the stay at work program, and I didn't think that I guess I didn't understand. I didn't think that was necessary because I felt that I could work the the lightweight areas of the zoo. They continue to say that there are no lightweight areas of the zoo, but there are areas of the zoo that you do not have to lift more than 30 pounds regularly. I mean, the aviary is mostly just hosing. So it's not, it's different from working the rhino where I was starting to train and I wanted to, that was one of the areas that I said I wanted to train in. But that is everything about a rhino is very heavy. The enrichment, the food, the feces, everything is very heavy. So every part of taking care of that animal is heavy. But birds are very small, and part of taking care of those animals is all very lightweight. So it was my understanding that since I had worked the aviary in the past with the 10-pound restriction, and my doctor informed me that I should be allowed restrictions in my job, that I should be able to work, the aviary. And like I said, I was willing to work all the areas in the zoo that I felt were lightweight areas: herpetarium, green barn, or a smaller, combination of the smaller areas that were available as well. Um, and that is when they told me that that Beth felt the safest place for me was the carousel. And that it, made her feel better to know that I was going to be at the carousel. That's also Shannon Meyer, and essential job functions are also discussed in the recording.
All right, I guess Attorney Mullen, I'll let you. I guess you want to continue to state your objection.
I guess if the end result is these documents are admitted, I would ask that as a supplement, my office has made like a rough transcription. It's not the best they could. Like I said, it's hard to tell who is speaking, but I worry that to allow the entire recording to be admitted, like that there would be completeness issues with it if she is going to, I mean, she's summarized it in a few words here, but obviously there is a lot more than that within those documents, and I would want to be able to rely on my understanding of what's in them to cross-examine.
I guess what's your position on that document, Ms. Bertrand? I know you haven't seen it, I guess, but
If she needs, if she's going to be using that to ask me questions, I think that that's fine.
all right. So what's the party's preference as to the recording? I think at the very least, I will need to play parts of it, Ms. Bertrand, for you to identify individuals. I am not opposed to listening to it outside of this hearing to save the
Okay.
party's time.
Okay.
But I guess I'll let the parties decide if they want the complete recording played here. And I guess Attorney Mullen, I would turn to you because I think the complainant already indicated she's fine with me hearing it elsewhere.
I mean, it's still my position is that I object to these exhibits being included at all.
Right. I know it's your objection. I'm going to overrule and allow that to be admitted as exhibits over the objection. Do we want the entire recording to be played on the record? Or do you want me just to play for the complainant to identify some individuals and then I listen to it at another time?
I suppose that's acceptable, but I'm wondering about the rough transcripts.
Right. So I know that the complainant said that was going to be fine. It looks like what's going to happen is we will be most likely breaking, I'm going to assume, before we get to cross-examination. That's up to the parties, though. But it's already 11:45, and I'm sure there's probably some more testimony potentially, but maybe not. And my recommendation would be then, if you have that as a prepared document, maybe send it to the complainant and to me. But complainant says she's fine with you using that as cross-examination and as a sort of a rough transcript. Obviously, the parties understand it's not an official transcript. Ms. Bertrand, you were saying that you're okay with that, but just with everyone's understanding that it's someone's best efforts at transcribing it.
And how would the transcription be used?
Just a question.
Yeah, so Attorney
Just a
Mullen
basic
wants to
question,
be
so.
able to question Ms. Bertrand, and obviously, the difficulty with audio recordings, especially of this length, is how to address that. So
Okay.
if there's a dispute, obviously, when you see it and you're being questioned, if you think that that's not accurately reflecting the recording, then obviously we can always go to the recording to the best that we can. If you're saying that's not what the recording says, because
Okay.
this is not an official transcript prepared by like a court reporter or anything like that. So, but I understand the concerns of trying to cross-examine, especially since we're not playing the recording on the record. All right. At the very least, I do need to. So, are we okay then? I will play some portions of it until I can get a sense from Ms. Bertrand of who is whom on the recording. But I will listen to the entire thing separately. Is that the position we want to take?
Yes.
All right. Let me see if I can.
Do you want me to, well, at the break, email the documents I have?
Yeah, I think so. At the break should be fine. Let me. Okay. Share. Include sound.
One for Susan and for Dan and for myself and Dan. It has a position description.
Can you guys hear that?
Yes.
Mhm.
Yes.
All right. I'm going to turn it up on my end at least. So who was that first voice?
That is Elizabeth Peterson.
Okay.
I've got one, just, some stuff that I think would be helpful for our meeting today. Shannon, I'm sorry, I didn't think of you. I got one for Susan and for Dan and for myself at the end. But it has a position description and class spec and correspondence from Susan and her doctor and the state at work policy that we'll be talking about today. Because I just spent much time navigating this stuff.
And Shannon is familiar because I contacted her when I had restrictions.
Who was that
That-
person speaking?
That's me.
Okay. And I guess I could have asked you, are there going to be large portions where before someone else joins in, or do these other people, first of all, do they all speak, I guess? should
I
roll.
don't think Joanna and Laura have very much to say. They may have a comment here or there. But
Okay.
Dan Lowndes should come in pretty soon and Shannon Myers come in pretty soon. And those are the key people in the conversation.
People. Okay. All right. Yeah. So I'm only really playing it so that I can get a sense of, again, who's who when I hear it. We will have that transcript, which may be helpful as well. But all right, let me go ahead and play.
Before I talk to you about it, because I didn't know I was going to have these restrictions, so that's why she's aware of this meeting and I invited her.
Got it. I don't think I've ever seen you in person, Shannon.
Yeah, it was like, I said, Dane, okay, where's the visitors center? Yellow building. Oh, got it.
I told Dan, I'm like, it's almost impossible to navigate.
Was that person Dan?
That was Shannon Meyer.
Before that, I thought I heard a man's voice. No, I'll keep playing it. till
No,
I
that
can-
was Shannon and then Beth.
Okay.
Talking
Unless you're kind of like.
She has
with
a
someone
low
and then-
voice.
Okay.
Yeah. So yeah, like I said, I, as a manager, have never navigated the stay at work policy or really the return to work. Most of the things that we've gone through in the last few years have been like a workman's comp type claim. So I know that they're quite different. So I had asked Dan to give us some guidance or some insight on, I want to make sure we don't do anything wrong, and I want to make sure that Susan is protected and that we're treating her in the way that she needs to be treated for medical restrictions. So, but I look to Dan for a lot of the other guidance.
Okay, so I'll just talk generally.
Okay.
So,
And that's Dan? I'll
Yes.
just talk generally.
first general rule is that all Dane County employees have to do all the essential functions of the job with or without an accommodation, right? That we don't pay full salary for half work, basically.
Okay.
There are lots of exceptions to that. The first is, in the rule, we generally work with or without an exception, or with or without an accommodation, get an accommodation through.
I don't think, were you listening for somebody else?
So we heard Laura already? Was that the
No.
low?
Shannon Meyer and Dan, and then myself and Beth, and then the other two, there will be long stretches before they probably speak. So I would, if you wanted me to,
And
I
was
could.
Shannon the one that had the low voice?
Yes, in the beginning, yeah.
Okay. And then Dan came in. Okay. All right. Stop sharing. All right, so I'm going to listen to that one separately. We've determined, and Attorney Mullen will provide a transcript. There's another recording. What is that recording of?
That was just the follow-up, and I believe it is just me, Beth, and Shannon, and that one, I would have to, that's our follow-up meeting
And when did that
on
take
June,
place?
June 28th, 2022. Approximately 3 p.m.
And who made the recording?
I made the recording.
Right. Is it a recording of the entire meeting?
Yes.
And is it a complete and accurate copy of that recording?
Yes.
Has it been altered or edited in any way?
No.
And what is that gonna show?
That is just the follow-up where they said, yes, they wanted me to join Stay at Work, and then, Shannon kind of reiterated, well, we have concerns. That was kind of the discussion before the email that came in with the ADA team and the Amy Tutwiler, because Shannon said she was going to discuss with them, that she had concerns about my new assignment. And again, we would try to, I guess I thought we were going to try to discuss a possibility of a new assignment.
And Attorney Mullen, I assume you're making the same objection,
Yes, I am.
and I will allow it to be admitted. Are you expecting to have a transcript for this one as well?
Yes.
All right. Is it the party's preference that I listen to this one separately also? I believe it's much shorter, is what you said, right? It's 18 minutes. Would you like me to listen to that one separately as well?
That's fine.
All right. And we've already identified people. It should mostly be the same thing. So, all right. Any other testimony, Ms. Bertrand?
That was all.
Oh,
good,
and I
please.
guess I remember at one point you had referenced a document that we were not going to admit, and you had mentioned that the recordings might have laid the foundation for that. Do you think that the recordings laid the foundation for that, or are you not intending to go back to that exhibit that was excluded? I can't remember. That might have been C-29.
Yep, that was C-29.
Oh, okay. Revisit that. Okay.
Well, I asked
it-
because then I might have to play the portion of the recording that lays that foundation, right?
Okay.
So what is it in the recording?
The
when it goes
only
back to
thing that
C-29?
is discussing is that I was asking why Mary was allowed to work just, Badger Flamingo, and they thought that she could have still possibly been on workers' comp during that time. And then just all the text message says is that she was no longer on workers' comp towards the end of her employment. But I mean,
All right. Well, here's
That-
what I'll
Go
ahead.
I still object to Exhibit 29. I'm not sure that this would lay the foundation for that, because it's essentially she's like trying to impeach the words of someone in this recording with this message, but that person isn't a witness. I mean, that's
Mhm.
still the problem with these recordings, is that they're not witnesses here. And
I mean, if you're allowing the schedule to
mean-
show, the schedule shows that she was in Badger Flamingo. I probably isn't necessary to have a text message saying that she wasn't on light duty workers' comp, because we don't have anything that says that she was either, right? So I guess it's just showing the schedules. I mean, that's up to you to determine, but the schedule's just
so-
showing.
we don't know when she retired, for
I was
starters.
just
Yeah.
gonna say,
It's
I was
like-
just gonna say that that's gonna be your biggest concern is I don't know what
When
time
did
that
she
is.
retire? Yeah.
Because that's all that she's, asserting in that statement is that
Okay.
she was not on light duty at the time she gave her notice. And we haven't established that. So what's going to be the significance of that document? I will say, over the objections, I will admit it, but just understand that its significance may be very light,
Mhm.
if any.
Okay.
But I'll allow C-29 to come in. Do you have other testimony, Ms. Bertrand?
When did you want to break for lunch? You want me to finish before?
How much more testimony do you anticipate? And I know that's hard for
Oh,
pro se
no,
people
not,
more so than, but
Does this include Eric, bringing Eric?
Yeah, we
as
have
a
to-
no,
witness?
Okay.
no. So when you will finish your part, Attorney Mullen can then cross-examine you, Ms. Bertrand. And then once that's done, you can do some rebuttal or redirect, we would call it,
Okay.
if needed. And then once your side is closed, then you can move on to Eric.
Okay.
And then the same thing, then Attorney Mullen can cross-examine him. So this is for you to finish your testimony before being cross-examined.
Okay.
How much time do you think? Because I'm assuming it's going to be relatively short, but I don't want to. I'm not trying to force you to. If I might think it's 30 minutes, but you might think you have 2 hours of testimony.
No,
You
no.
know?
No, I was just going through the exhibit. So I mean, I wouldn't mind breaking for lunch if you wanted to do that first.
Are you intending to give other testimony?
Just to finish up my final statements, I guess.
All right, Attorney Mullen, do you want to break for lunch now?
I mean, I guess I'd prefer to have a 5-minute bathroom break now and have her finish up and then have the lunch break.
Yeah, I mean, it's typically a better break for you to go ahead and finish your testimony. Because otherwise, whenever you break up testimony, and it's just a little weird, and then obviously the break gives a time for the respondent to prepare the cross-examination. So that would also be my preference. So if you want, I can give you a break. If you want like a 5-minute break,
Yeah, 5 minutes would
just to
be
kind
great. and then
of
we'll-
collect your thoughts, and then we'll call it 12:05. Let me go ahead and stop the recording.
Sounds good.
Okay.
Thanks.
Thanks.
12:05.
Um,
All right, we are recording again. It is 12:07 p.m. on February 19th, 2025. And Ms. Bertrand is continuing her testimony. Go ahead.
Okay. So again, the Wisconsin Fair Employment Act requires employers to treat pregnancy as it would treat other medical restrictions not related to pregnancy. I was not treated the same with my restrictions due to pregnancy as other zookeepers and have been. I will call a witness after break, Eric Anderson, who has worked the aviary with restrictions, and he was allowed to stay in his area. The respondent will try to say that I, had too many requests. I'm looking at their evidence, and I can see that that's where they're going. Is I'm asking for too much preferential treatment, but as my emails indicated between management and staff, they are regularly asking us where we want to work. So that's, I didn't feel that I was asking too much to ask to be put into the lightweight areas of the zoo. Management enforced climbing restriction on me because I mentioned that my doctor said in the first pregnancy meeting, I mentioned that my doctor said climbing could be a concern as I get later into my pregnancy, and that is for all women. She just stated it as a general term for all women who are pregnant. You can become unbalanced. So that was part of the reasoning why management said I could not work in the herpetarium because there
Just
was
going
a
to object to that. That
Oh.
calls for speculation. As
Is
far
this in the recording?
she's speculating as far as what the management thoughts are. She hasn't. I'm just objecting. I'm just making an objection for the record.
Right. Yeah, all right. You can continue with your testimony.
Okay. I was told by management that I could not work in the herpetarium because I had expressed concerns about climbing, even though I reiterated that I actually followed up with my doctor and said, "Can I climb a ladder?" And she said that was fine. The herpetarium has ladders. They're metal. They're only 3 steps. They're secured to the wall. I was not concerned about climbing in the herpetarium, but because I said climbing could, be an issue later on in pregnancy, they then enforce that upon me. Um, so let's see. So that was part of the reasoning for saying I couldn't work in the herpetarium, but they never really gave any good reason why I couldn't just work flamingo, badger, porcupine. So they said that the areas were going to be reorganized, but that never happened. So I asked of my management to, accommodate a pregnant woman. I think that we work a hard physical job, but that doesn't mean that we don't deserve to be safe when we're pregnant, and then that our babies don't deserve to be safe. So I'm here today to hope that we can get this issue resolved so we won't have, so we will have light duty defined in the county. We should have specific areas that are defined as light duty roles. So when someone needs light duty, that is, and it's available, then they get that light duty work. If light duty work is available for Eric with a shoulder injury, then light duty work should be available for me with a pregnancy.
I'm just going to object that this is argument that, rather than testimony.
Right. And you're
Okay.
kind of getting into sort of remedies that you're seeking, which we
Okay.
don't need to get into right now.
Okay.
So just more testimony if you have some about the discrimination
Okay.
that you experienced.
I think the basics is just that I was not treated the same as other employees, and I will show that with Eric's testimony after break, or eventually.
All right. You have any other testimony for yourself?
No.
Nope. Attorney Mullen, do we want to break for lunch and then get into cross-examination?
Yes, please.
All right. How much time do the parties want? Do you want to come back at 1 o'clock, 45 minutes-ish?
Yes.
Or
That's fine.
1 o'clock? And then Attorney Mullen, you'll be providing the transcripts for those recordings.
Mhm.
All right. So then we can come back at 1 o'clock. Let me stop the recording.